stand in your holy presence as our Supreme Judge, we humbly beseech you to bless and inspire us, so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with eternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
Muli nagpapatuloy po ang special coverage ng inyong People's Television. Kaugnay pa rin po ng ginagawa ng Judicial and Bar Council. Kaugnay pa rin po sa public panel interview sa nagsimula pa kaninang alas 9 ng umaga. Sa mga oras pong ito ay nasa loob na ang ilang miyembro po ng Judicial and Bar Council na magsasagawa o magsisilbing wall panel para po maumpisahan ang susunod na mga isasalang dito po sa ginagawang public panel interview. Inaasahan na sasalang susunod si Ginoong Samuel Martires, si Ginoong Ricardo Paras at si Noel Tiham. Kanina ay habang nakabreak dito sa loob ng Korte Suprema ay sumalang na itong sina Attorney Persida Acosta, Presiding Judge Rowena Adlawan, kasama rin itong si CA Justice D. Ampao, at nagkasama rin itong si Attorney Jimeno na siyang naunang sumalang na nagsimula pa kaninang alas 9. Narito po, pakinggan natin.
Attorney Carriosa.
Thank you, Justice Gutierrez. Good afternoon, Justice Martires. The records show that this is the first time that you have aspired for the Supreme Court. Is this accurate?
Found out that one of the applicants was Justice Jose Catral Mendoza, because I was one of those who was asking him to apply for the Supreme Court, and he kept on refusing. But when I convinced to apply, I had to withdraw my application.
That was quite some time ago.
Yes, Your Honor.
And it has, in fact, you have been in the Sandigan Bayan since 2006?
2006, Your Honor.
And what made you decide to apply now?
Honestly, Your Honor, I was thinking of applying for the office of the Ombudsman because I heard that the Ombudsman was planning to retire early from the service. But when I heard that the Honorable Conchita Morales, Carpio Morales, decided not to retire, I instead applied for this vacancy of the Honorable Jose Perez.
You turned 68 in January. That's right?
Pardon, Your Honor.
You turned 68
Yes, Your
in
Honor.
January.
Yes, Your Honor.
Which would mean that should you be nominated and appointed, you shall serve the High Court only for 2 years.
Yes, Your Honor.
Okay. Assuming that you have 24 months, okay, do you think that it will be possible for you to finish the over 1,000 cases that are expected to be assigned to any justice who would assume the next vacancy in the Supreme Court within the 2-year period?
I always believe in miracle. I always believe in prayers, and I think with a little work, I might be able to reduce that 1,000 cases that is assigned to a particular justice, probably by half. That would depend on my health also. But I always, as I said, I always believe in prayers, and that's the only way I can discharge my duties and functions should I be appointed to the Supreme Court.
Since you mentioned health, how is your health? Have you had any procedure done on you lately?
Luckily, Your Honor, I have not undergone any procedure. The only medication I'm taking is losartan, which my cardiologist prescribed me to take, because he said that when a person reaches the age of 50, you have to take some maintenance medicine to regularize your blood pressure.
Thank you, Justice. Now, the records will show that before you became a Sandigan Bayan Justice, you were an RTC judge.
Yes, Your Honor.
And prior to that, you were in the private practice of law, and you were also an assistant department manager, legal department of the Ministry of Human Settlement.
Yes, Your Honor.
Now, considering that most of the cases that you're handling now are graft cases, so there has been, well, your exposure now to labor law cases and even other fields of law are quite limited. How have you prepared for the other cases that you would have to deal with or to take action on should you be appointed to the Supreme Court, such as cases on taxation, cases involving other fields of law other than graft cases?
A case before the Sandigan Bayan was filed involving the Development Bank of the Philippines. The defendants there were the chair, Rinaldo David, and a private citizen by the name of Roberto Ongpin. That case involved some issues on about taxation and its relation to insider trading. I was able to decide that case properly insofar as I am concerned. But to keep me abreast also, whenever I have the time, I try to read decisions of the Supreme Court on some important matters or events or cases that is being decided by the Supreme Court.
Are you computer savvy? Are you computer literate?
I encode my decisions personally. I only know about Word. I can do research from the internet. That's what I do, Your Honor.
With regard to case management, how do you determine which decisions to prepare for, or how do you determine which cases which have already been submitted for decision to work on first?
I just assume the chairmanship of the second division, where I have the, should I say, the power to manage the caseload of the division. I work on which of these cases had first been submitted for decision and give it a priority before other cases submitted for decision should be decided by the court. So in short, the first in, first out is the policy that I adopt at present, Your Honor.
How much reliance do you have on the use of technology in helping you manage your court docket?
Well, I always, actually, I do supervise it personally, the Office of the Clerk of Court. I always want to be informed daily on the pleadings that are submitted by the parties, so that if these pleadings can immediately be decided by the court, like motions for extensions of time, I immediately dispose of that, so that the matter of being heard on a motion day should be dispensed with, and the court will be given more ample time to concentrate on other matters.
For the cases that are assigned to you, how much time does it take you usually to do an extended resolution, not just on postponements, something that would require more substantial content?
I think there are times when it depends on the case and on the issues involved and the documents or the evidences takes me about between 3 to 6 months to decide a case that are complicated. But that is complicated, I'm sorry.
Including resolutions?
Depends again on the resolutions. If it is just a matter of a motion to file demurrer to evidence, and I decided to deny that, it only takes me about a week or 2 weeks to deny that demurrer to evidence. But if I have to grant the demurrer to evidence, I have to study that carefully because I have to discuss the reasons for the granting of the demurrer.
Thank you, Justice. In the case of People versus Carlos Flores Garcia, I believe you penned this, and you began by saying, and I quote, "The law must not just be spoken as written, it must be administered and enforced according to its letter and spirit," end of quote. As the interpreter of laws, the Supreme Court decisions are jurisprudence and form part of the law of the land. Do you agree that the Supreme Court commits errors every now and then, and how would you avoid this should you be appointed to the High Court?
I would agree that sometimes the Supreme Court commits errors. I have a case that I decided when I was a presiding judge in Agoo, La Union. I convicted the accused for murder. When the case was brought to the Court of Appeals, the decision was modified to frustrated murder. And when the case finally reached the Supreme Court, the decision was the accused is only guilty of serious physical injuries. But the victim in that case died. So I would say that the decision that the Supreme Court made an error. To avoid this, I always try to read the records of the case. I do not rely on my researchers to give me a statement of facts. Even on jurisprudence, when I ask them to make a research for me, I always ask them to hand me over the decision that they are citing in a particular case. To borrow the lingo of the Tagalogs, nagiging sigurista lang ho ako.
Thank you, Justice. And I have the warning light there, so this is my last question. Actually, it is based on a comment made by one of our respondents. Is it true that they made a courtesy call to the President? Why was it necessary for them to make a courtesy call? Were they not concerned that it might affect their independence? Was he contemplating rather that he would be aspiring for the High Court? Would you care to comment?
In all honesty, Your Honor, I did not make a courtesy call to the President. Neither did Justices Fernandez, Ekong, and Queiroz make that courtesy call. We went to Davao City to conduct a out-of-town hearing. We arrived in Davao on a Sunday. We were informed that afternoon when we arrived that the President was going back to Manila. On Tuesday, I was asked by one of the justices if I am willing to see the President. And naturally, any person in his sane mind will always say, yes. Who am I to say I don't like to see the President? So I said yes. I said, why? He said the President would like to meet us on Thursday. I said, how would it be possible when the President is in Manila? He said, no, the President is going back to Davao on Thursday because I think Wednesday he was scheduled to go to Jolo or one of these towns in Mindanao. So Thursday we were on our way to the President's office at the Department of Public Works when suddenly I received a text message from Justice Teresita Baldos, now retired from the Sandigan Bayan, telling me that, wow, you are going to see the President. So I asked her, where did you get that news? She said, it is now through DZMM, double M. And then a few seconds, my wife also texted me that said, so you're going to see President Duterte. I said, where did you hear that? She said, also from ABS-CBN. On our way, I hope that event was recorded. I was really angry. I was angry at the president's men, especially the ones handling the media, for leaking this information to the media. I was telling the other justices that I will confront whoever is handling the media affairs of the president, that this is a private affair. This is a private invitation from the president. It will give a very bad impression to the public that we are going there because the president is going to ask us for something. We did talk to the president that evening. We spent 4 hours with him, but not a single case did the president ask us what that case is all about. The president only told us about his war on drugs. He told us about his student days, his life as a student. He told us about his experience within Justice Solidum as his professor. He told us about the history of the Muslims. Nothing, the president told us that I respect the judiciary. I will never interfere in the affairs of the judiciary. But honestly, Your Honor, I almost did not join the group that evening who went to see the president. And I think the justices who were with me could attest to that, Your Honor.
As I mentioned, Justice Martirez, that was my last question, and good luck.
Thank you very much, Your Honor.
Thank you, Madam Chair.
Thank you, Attorney Carriosa. May we request now Attorney Mejia to continue?
Thank you, Madam Chair. Good afternoon.
Good afternoon, Your
Justice
Honor.
Martirez. Let me just, in connection with that particular incident where you met under those circumstances with the President, and given the opportunity now to explain your side, what assurance can you give this body that you will maintain your independence should you be appointed as the next, as one of the associate justices of the Supreme Court?
I have always maintained my independence, even before I joined the judiciary. I used to work, or I worked with the Ministry of Human Settlements. My superiors there could not tell me what to do, especially when it comes to legal matters. It is very unfortunate that after the EDSA revolution, people kept telling me that I am pro-Marcos. But during the time of Marcos, I was really on the streets, joining rallies and demonstrations. When President Aquino became president, I'm referring to the son, they also had been telling me that I am pro-GMA. But as I had said in one of my decisions, that the court should not be influenced by any king or president. We should only rely and make our decisions pursuant to the evidences presented and the applicable law. I have maintained my independence in the Garcia case, even if it meant that President Benigno Simeon Aquino III was mad at the Sandigan Bayad, particularly at me and Justice Baldos. I insisted on what was right, or what is right, and I didn't care what Malacanang would do to us. I even heard that I was the subject of a background investigation, whether I earned from that case or not. But I maintained what I thought was right. I insisted that the office of the Solicitor General cannot intervene or appear before the Sandigan Bayan.
Thank you. what do you think are the major problems plaguing the judiciary today?
There is only one problem that two problems. One is corruption, and the other one is the perceived interference of some government officials, and actually, if I may add, the trial by publicity of which media plays a very important role. These are the problems that the judiciary is facing these days, Your Honor.
How do you intend to address this should you be lucky enough to be appointed as one of the associate justices?
We cannot correct public opinion, especially what media would write. A reporter may submit his report to his editors, but the editor can always edit the report of a particular field reporter. We cannot over time change the judiciary by putting in honest officials or honest judges. It is very hard to determine at first who will be honest and who will not be honest. The lure of money is very tempting. It takes someone to be able to say no to accept a gift or money in consideration of a case.
Tweeted question just came in, and this will be my final question. You were admonished by the Supreme Court on January 15, 2013. Why should the JBC not consider that against your application?
When I was first appointed to the Sandigan Bayan, one procedure that the Sandigan Bayan was adopting was to schedule an execution of judgment. I asked my chair, Presiding Justice Edelberto Sandoval, that this is the only instance where we have to schedule an execution of judgment which is not provided for under the rules on criminal procedure. But I was told by Justice Sandoval that this practice by the Sandigan Bayan was adopted during the time of then Presiding Justice Francis Garcitorena, who according to him wanted to give the accused all the chances of availing of whatever remedy there is. So I knew we were violating the rule, because insofar as I am concerned, once the Supreme Court issues an entry of judgment, there is nothing more for the lower court to do but to issue a mittimus. When I was transferred to the 3rd Division, there was this case of Velasco, where the Supreme Court, in that case, where the accused filed a petition for certiorari before the Supreme Court. The accused was convicted by the Sandigan Bayan. The Supreme Court dismissed the petition for certiorari. The accused filed a motion for reconsideration. The Supreme Court denied the motion for reconsideration. The accused filed the second motion for reconsideration. Again, the Supreme Court denied the second motion for reconsideration. The accused changed his counsel, and the new counsel filed another petition for certiorari. When that petition for certiorari was filed, the Supreme Court directed the Office of the Solicitor General as well as the Office of the Special Prosecutor of the Ombudsman to file its comments. And then the Supreme Court referred the matter to the en banc. Justices Villaruz and Queiroz, including myself, were of the impression that the Supreme Court might give due course to the second petition for certiorari because it was referred to the en banc. In the meantime, a complaint was filed against us by the private complainant in the criminal case. The en banc denied the second petition for certiorari. We explained to the Supreme Court that we could not execute the judgment because the Supreme Court has entertained the petition for certiorari when it could have outrightly dismissed the second petition. I explained also in my own reply that we are not covered by Rule 65, that we have to await for a temporary restraining order in order for us to proceed. Because the decision has already been promulgated, and therefore there is nothing for the Supreme Court to restrain us from doing. The decision of Justice Bernabe said that we should have waited for a temporary restraining order, but because there was none, we should have proceeded with the execution. But I said this is no longer covered by Rule 65. In criminal actions, the proceedings start from the arraignment of the accused to the promulgation of the decision. We were just awaiting the finality of judgment from the Supreme Court and the final entry. There is no temporary restraining order. And we also said that had the Supreme Court granted the second petition for certiorari, reversed the findings of the Sandigan Bayan convicting the accused, and in the meantime we sent the accused to the National Bilibid prisons, can we unwind what we have done? In a worse scenario, Justice Villarus, may his soul rest in peace, said that supposing it was a death penalty and we executed that, how do we now bring to life an accused using that ponencia of Justice Bernabe? We took it, we accepted that decision. We cannot do anything. That was the view of Justice Bernabe when we were admonished in that case.
That was my final question. Thank you and good luck, Justice Martirez. And thank you, Madam Chair.
Thank you very
so
much, Your Honor.
Attorney Mejia. May we call now Judge Ilaw to continue?
Thank you, Justice Gutierrez. Good afternoon, Justice Martirez. And
Good
how are
afternoon,
you
Your
today?
Honor. I am okay, Your Honor. I'm good.
All right, as an Associate Justice of the Sandigan Bayan, incidentally, Sandigan Bayan has a limited jurisdiction. Would your knowledge in law in connection with the Sandigan Bayan cases and your experience as such will be enough for you to be nominated as an Associate Justice of the Supreme Court?
With no offense meant to anyone, Your Honor. I think my experience as a presiding judge of the Regional Trial Court, and now with my 10 years in the Sandigan Bayan, I think I am in a better position than those who came from private practice, who came from the corporate world. I think I have now a better perspective and a better grasp of how cases should be decided, of how it should be treated, of how to think of the welfare of the citizenry vis-a-vis the issues of a particular case, Your Honor.
All right, you singled out private practitioners. How about those associate justices in the Court of Appeals eyeing or jacking a position as associate justice of the Supreme Court?
The associate justices of the court, I'm sorry, Your Honor, nobody has a monopoly of knowledge. All of us went through 4 years in the College of Law, and I guess the Supreme Court or the Court of Appeals justices are very much also qualified to go to the Supreme Court. If I cannot compare myself to any one of them. I would even say that they might be intellectually better than I am. I could only compare myself to them when it comes to morals. And I could say that probably I am on par with them when it comes to morality. But when it comes to intelligence, I would say that I probably would submit to them and say that they are probably intellectually better than I am.
All right, you have been unanimously endorsed by the Integrated Bar of the Philippines Quezon City Chapter to become an Associate Justice of the Supreme Court. How and why do you think you were able to garner the unanimous vote among the members of the IBP Quezon City Chapter? Did you campaign for it?
I think most of the officers of the Quezon City Integrated Bar of the Philippines Chapter, the Quezon City Chapter, most of them have cases before the Sandigan Bayan, and most of them had a chance to observe my demeanor in court. I think most of them are happy with the decisions that I have made, with the rulings that I have made when I am presiding. Most of them probably, I could only say probably, are contented, especially with my dissenting opinions. Although I would say that one of the officers there, Donna Alagar, who is one of those who endorsed me, lost the case before the 3rd Division. So probably the only reason why it was unanimous is because they have full trust in me. That is my guess, Your Honor.
All right, the letter also commended your competent management of the court. Can you elaborate on this?
I never allowed counsels to argue for more than 5 minutes. I always make a ruling immediately when an objection is raised. Probably that is what the referred to as court management, Your Honor.
Competent as well as sound management.
I cannot that is the words of the officers of the Integrated Bar of the Philippines, Your Honor. Probably that is their view that I am a competent justice of the Sandigan Bayan, especially during trials. Competent when I write my decisions. It is supported by the facts and the law. I don't know, Your Honor, that's probably how they view my conduct as a justice of the Sandigan Bayan.
There is a Twitter question, maybe in general, have addressed to you, Justice Martires. Have anyone ever approached you to influence your decision on a case?
If I say no, Your Honor, I'd be a liar. Yes.
And
even when I was a judge, Your Honor, a lot of people would come to me trying to talk to me about a particular case.
And how did you handle it?
I remember clearly when I was a judge in Agoo, when an accused in a rape case was one of the trusted bodyguards of the mayor of Agoo. Some of the bodyguards of the mayor talked to me, tried to influence my decision by telling me that there was no rape. They were telling me that the victim was actually the girlfriend of the accused. I knew the accused was very close to the politicians in Agoo. But I still I convicted the accused, despite the influence and the threats that I received from some of his friends. I was also told when I was writing my decision in a particular case, I'd like to remember that. Yeah, there was a case. I forgot the title of that case, but there was a case when I was being offered 1 million pesos just for me to acquit the accused. I said, if it is 1 billion, I will accept it. I convicted the accused, and it is subject of an appeal to the Supreme Court.
Why the offer is low?
1 million is very low for me, Your Honor. Although I don't have 1 million pesos, I'd like to secure my family with a 1 billion. I can live in Europe, in one of the countries, probably Lithuania or Latvia, and if I have 1 billion pesos, I can easily go anywhere in the world.
And I presume that you may have displeased many politicians in your career as an Associate Justice of the Sandigan Bayan. Is this true?
Pardon, Your Honor?
You may have displeased politicians. Displeased, please. Displeased.
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 I am displeased with the Sandigan Bayan?
No, politicians.
Oh, I respect these politicians, and in fact, no politician has ever tried to influence me or talk to me. And it surprises me that none of these politicians came to me. The case I am talking about only refers to a case of a municipal mayor in Luzon. The one who talked to me is a retired government official, not a politician. But none of the politicians, I think, because you know, Your Honor, I don't think I have displeased any of the accused that I have convicted, because a criminal, as far as I'm concerned, knows the crime that he has committed. The criminal would only hope that the prosecution will make a mistake, and that mistake might eventually result in the acquittal of the accused.
What did you learn from your seminar on corruption, detection, prevention, suppression in Paris, France? Have you applied your learnings at the Sandigan Bayan?
One particular aspect of that seminar that I learned is that there is a gender difference in corruption, that women are less corrupt than men. This is actually findings of some of the researchers of the World Bank. They say that women views corruption as risky. Women are highly moral than men. Women, the research paper says, are strongly influenced by moral values or by their peers. Women do not belong to exclusive men's group on corruption, and no women's group has ever formed an all-female corruption group. This is one thing that I learned. I also learned that there are two types of corruption. One is the political corruption, and the other one is bureaucratic corruption. I also learned that, like the Philippines, France is also corrupt, especially Marseille, a city in south of France. So I was of the impression that corruption is not the sole domain of the Filipinos or of the Philippines.
Is that not gender insensitivity? Would male magistrates agree to your observation and learnings?
This is a report of the World Bank on corruption. And I tend to agree with that report that female in government service are less corrupt than their male counterparts.
The council, this August body is balanced. We have 2 women and 2 males.
I think the 2 members, Your Honor, are the exceptions to this all-male club.
All right, what is the general tenor of your rulings on cases regarding violations of Republic Act 3019, the anti-graft and corrupt practices?
My view, the tenor of my rulings, actually, Your Honor, I have more acquittals than convictions with respect to cases before the Sandigan Bayan. With no offense meant to the Commission on Audit, if only the lawyers representing the accused in most of the cases pending before the Sandigan Bayan that were filed by the Commission on Audit, if only the lawyers would study the rules and regulations of the Commission on Audit, I think between 85 to 90% of the cases filed by the Commission on Audit before the Sandigan Bayan will be dismissed.
That's how you measure
Yes, Your
legally
Honor.
and personally in acquitting or convicting an accused so that you could sleep soundly at night?
I think it is better to acquit when you have doubts than to convict, Your Honor. A person who is guilty and later on acquitted at least is the one who will suffer. An accused who has been acquitted but is actually guilty will actually suffer for the rest of his life. He will be haunted by that one indiscretion moment in his life. I could sleep soundly because I know I did nothing wrong in acquitting any of these accused. And if I go back again to my observations on the Commission on Audit, Your Honor, just recently the 5th Division, where I was appointed as a special member in the case, granted the demurrer to evidence of then Mayor Elinita Binay. I concord with the ponencia of Justice Arturo D. The case arose from an audit conducted by the Commission on Audit with the team leader Heidi Luce Mendoza, now with the United Nations. The audit was conducted when the Makati City Hall
My time
building.
is up. Only one last question, please.
Yes, Your Honor.
All right, do you think you were able to live up to your promise in treating Senator Enriquez's case with fairness?
Yes, Your Honor. Insofar as that aspect only of the Bill of Particulars is concerned. But now, Your Honor, I am out of the Enrile case because I am now with the 2nd Division, and the case of Senator Juan Ponce Enrile is still with the 3rd Division. Although the motion to quash filed by Lucila Gigi Reyes, I am still part of the division when that motion to quash was submitted for resolution.
Which shows allegedly your integrity, competence, probity, and independence, Justice?
We have not yet decided the motion to quash on Lucila Reyes. On the Enrile case, Your Honor, I only participated up to the extent of the Bill of Particulars where the court denied the motion of Senator Enrile, and which resolution was reversed by the Supreme Court.
All right, thank you very much. No further questions. Good luck, Justice Martinez.
Thank you very much, Your Honor.
Thank you, Judge Ilaw. And now my turn. Good afternoon again, Justice.
Good afternoon, Justice Gutierrez.
Okay. You know, one of the rules of the JBC in determining the qualifications of candidates for nomination is to determine their mastery of laws, rules, and jurisprudence. So I have just few questions on legal points. The Supreme Court recently promulgated 2 decisions in cases from the Sandigan Bayan appeal to the Supreme Court. I'm referring to the case involving former President GMA. Of course, you have read the decision of the Supreme Court,
Yes, Your Honor.
actually granting the mirror to evidence and acquitting GMA. If you were a member of that court, would you have concurred or dissented?
If I were a member of the First Division who first denied the demurrer to evidence of President Gloria Macapagal Arroyo, I would have joined Justice Ponferrada, who dissented from the resolution
The
of the court.
question is, would you have, if you were a member of the Supreme Court, would you have concurred or dissented in its decision?
Yes, Your Honor.
We are now in the Supreme Court,
Yes, Your
not
Honor.
in the Sandigan.
Yes, Your Honor.
You are concurring,
I will concur that the case
and
against
therefore, in effect, you are granting
the demurrer,
the
Your
demurrer
Honor.
to evidence.
Yes, Your Honor.
You were not a part of the division.
No, Your Honor.
Have you read the facts and the evidence presented before the Sandigan Bayan?
Not entirely, Your Honor, but the issue, I think, in the Gloria Macapagal Arroyo case was the amassing of wealth.
365 million. And in view of... So you are concurring? Why?
I will concur, Your Honor, because
Why just...
there is no proof, Your Honor, that the President amassed wealth. A series, because in amassing of wealth, it must be a series or combination of acts, Your Honor. That is the definition in the plunder case. It is just the amount is not, the threshold amount of 50 million is not the determining factor. The determining factor, Your Honor, in the amassing of wealth is that it must be done through a series or combination of acts. If there was only one act done, even if the amount involved is 1 billion pesos, Your Honor, there is no plunder.
But have you read the decision of the Supreme Court?
Not in its entirety, Your Honor.
Therefore, you cannot, analyze the evidence before us now.
Not really,
You
not,
should
not
read it
intelligent, Your
first
Honor.
before you can conclude that you are concurring. How about the case of Senator Enrile, where the motion before the Sandigan Bayan by his lawyer was only to fix bail, and the decision or resolution was that the motion is premature. Now the case reached the Supreme Court, and the Supreme Court granted bail even if there was no hearing before the Sandigan Bayan to determine whether or not the evidence was strong. Again, if you were a member of the Supreme Court, would you have concurred or dissented?
In the motion of...
How you will decide cases when you reach the Supreme Court?
I read the ponencia of Justice Bersamin on the bail petition of Senator Enrile, and it did not deal so much on the legal issues, Your Honor, but more on the health of the accused. In the motion to fix bail that was filed before the Sandigan Bayan, I was asking the counsel of Senator Enrile if that motion to fix bail could be considered as a petition for bail and if they were willing to join. Had Attorney Mendoza, the counsel of Senator Enrile, considered that motion to fix bail as a petition for bail, honestly, Your Honor, with the evidence that was presented by the prosecution in the petition for bail of Napolis, I would have also granted the petition for bail of Senator Juan Ponce Enrile.
Let us go back to the constitutional provision and the provision under the rules. These provisions were not relied upon by the Supreme Court because under the Constitution, all accused are entitled to bail except those charged with capital offense when the evidence of guilt is strong. As I said, there was no hearing. And the motion was only to fix bail on the grounds that there are two mitigating circumstances. Number one is voluntary surrender, and number two is his age. Now, if you remember, again, this question of the court or the ponente, how would you decide?
With all due respect to Justice Bersamin, I think I will dissent from the ponencia of Justice Bersamin.
You will?
I will dissent, Your Honor.
Okay. Very good. On what grounds, Justice?
The mitigating circumstances that was being cited by the accused Enrile should not be ground for granting bail, because the rules of court is very clear that in the denial of bail, there must be strong evidence to deny a petition for bail. The rules of court never mentioned about considering mitigating circumstances or age as a factor in granting a petition for bail. The rules of court tells us that in the granting of a petition for bail, the court must rely on the evidences presented by the prosecution during the hearing of the petition. So if I were a member of the court that granted that petition for bail of Senator Enrile, I would have dissented, Your Honor, from the ponencia of Justice Bersamin.
Yes, because the decision was not based on the constitutional provision or the provision under the rules of court. Okay, let's now come to the decision of the Supreme Court with respect to this, or in the case of Marcos Brion. Okay, again, the same question. If you were a member of the High Court, would you have dissented or concurred in each decision declaring that President Duterte, in announcing that the president or the former president may be entered in the libingan ng mga bayani, did not violate any law or jurisprudence? In other words, he did not commit any grave abuse of discretion.
I had a chance to read the digest of the ponencia and the separate concurring opinion of Justice Jose Catral Mendoza, as well as the dissenting opinion of Chief Justice Maria Lourdes Sereno. I would rather concur with the separate opinion of Justice Mendoza that this is more of a political issue than a justiciable one, that it is the President's prerogative to determine who should be buried in the libingan ng mga bayani for as long as that person complies or falls under the provisions of the law and who should be buried in the libingan ng mga bayani.
Dissenting, concurring.
I will be concurring with Justice Mendoza, Your Honor, that it is
Saying
more
that
of a
the issue is political.
It's more political, Your Honor.
You know, there are several issues, not only political. For example, the locus standi, whether or not, you know, under substantive issue, whether it's political. But, you know, if you read the ponencia written by Justice Peralta, he discussed the reasons why the former president should be entered in the libingan ng mga bayani. Two reasons. According to him, because he based his conclusion not on any law, but on the Armed Forces of the Philippines Regulation G number 1313765, enumerating the deceased or names of those people who are entitled to be entered into the libingan ng mga bayani. Among them are presidents or commanders-in-chiefs, secretaries of the National Defense, chief of staffs, etc., etc. But there are two exceptions. Those who were dishonorably discharged from the service. And number 2, those convicted with crimes involving moral turpitude. And so, in the dissent of Justice Carpio, he said, the President was dishonorably discharged by the people themselves during the EDSA Revolution. Although he was not convicted by the court of crimes involving moral turpitude, but he committed serious offenses like murder, torture, so many other offenses. So this is the dissenting opinion of Justice Carpio.
Carpio.
So given these facts, would you have sided with Justice Peralta, saying that he was not dishonorably discharged because he did not commit any offense under the Articles of War? There was no proceedings before any martial law that he was discharged dishonorably. Number 2, the President was not convicted in any court of any crime involving moral turpitude. So these are the basic issues in this decision. Now, what is your opinion, Justice? Who is correct?
I would say, Your Honor,
Would you have concurred with Justice Peralta or with Justice Carpio?
I would have concurred with Justice Peralta if that was the case, Your Honor, because I don't believe that the former President Marcos was dishonorably discharged by the Filipino people. When we talk of one dishonorably discharged from the service, especially in the military, we talk of a decision of the court-martial that discharges dishonorably a member of the armed forces of the Philippines. This is not the case of Ferdinand Marcos. It has always been my belief that the president or the former president was not actually ousted by the Filipino people, but he opted to obtain peace. He opted to leave Malacanang and go to Hawaii just to obviate or prevent any untoward incident that may happen in EDSA. So I don't think that it was the Filipino people. If the Filipino people were able to force the president from leaving Malacanang, it was probably part of it, Your Honor. No, Your Honor, I am from Samar.
You're from Samar. But because of that revolution, because of you are changing history, because of
That is my belief, Your Honor.
That's your personal belief. He was driven away. In fact, in one of the cases decided by the Supreme Court, Manglapos case, remember?
Yes,
the
Your
Supreme
Honor.
Court itself declared that Marcos is a dictator, and that's why he was forced to leave the country. Anyway, you have your personal view, but I still am dissenting against the decision of Justice Peralta. Okay.
Well, as I said, Your Honor, if I may, I would have concurred with the separate opinion of Justice Mendoza, and just concur in the results probably of the ponencia of Justice Peralta, but more on I would concur more on the decision or the separate opinion of Justice Mendoza.
I believe that's not only a political issue. It involves, in fact, the people. It involves questions of law. Whether or not, President Duterte acted on the basis of the present regulation, as what I mentioned before. Sometimes the Supreme Court, in answer to the question of Attorney Cayosa, commits errors.
Yes, Your Honor.
And I agree with you. Can you cite at least 2 decisions wherein you believe the Supreme Court committed errors?
One of the decision is that decision where a case for murder, the victim died, and the Supreme Court said the crime committed is only serious physical injuries.
Anyway, the JBC wants to know a landmark decision.
One of the decisions that apparently the Supreme Court made a mistake, and which actually is still the subject matter now of discussions among law students, is the case of Javillana versus Executive Secretary.
What is that case all about?
This is all about the whether or not the 1973 Constitution already took effect.
Javillana.
Javillana, yes, Your
Javillana.
Honor.
In fact, that is the most disastrous decision ever rendered by our Supreme Court. Okay, the red light is there warning me to stop. Okay, thank you, Justice, and good luck.
Thank you very much, Your Honors. Thank you.
The honor is Chief State Counsel Ricardo V. Paras III from the Department of Justice.
Good afternoon, Attorney Paras.
Yes.
So, continuation of the public interview. May I request Attorney Cayosa?
Thank you, Justice Gutierrez. Good afternoon, Chief State Counsel Paras. Our records show that we last interviewed you in 2014 when you applied for a position in the Sandigan Bayan. In fact, you were included in the short list. Today, however, you are not just an aspirant for the Supreme Court, but you have also submitted your application for the Sandigan Bayan again.
That is
How
right.
about with the Court of Appeals? Did you want to be considered for the Court of Appeals as well?
No, my application, Your Honor, is for the Sandigan Bayan and the Supreme Court.
Our records also show that you did apply for the Supreme Court last year in December, but you withdrew your application on the ground that you were nominated for candidature of the Philippines to the seat in the UN Committee on Economic, Social, and Cultural Rights. What has happened since candidacy?
That is right, Your Honor. The then Secretary of the National Economic Development Authority nominated me, upon my surprise, to be a member of the ECOSOC committee, which will review the performance of states in the compliance of the Covenant on Economic, Social, and Cultural Rights. However, there has the Department of Foreign Affairs could not pursue my application since the geographical distribution of the committee was already filled up, and it was reserved for China. In the United Nations, Your Honor, they would like to give in to whoever is first, which submitted its recommendation. So I had to, well, I was not nominated. I did not pursue. The Department of Foreign Affairs did not pursue my nomination.
Should you have been nominated and I guess an appointment, for that position, when would you have assumed? When would you have assumed office? Should you have been appointed to that position?
Your Honor, the committee meets 4 times a year. For every time they meet to review certain states on the report, it will take at least 1 month. So I will be out of the country for 4 months.
Okay. Thank you, Chief State Prosecutor. Now, the records also show that you still have a pending ombudsman case. When we verified just end of October, there is a motion for reconsideration in the case filed by a certain Attorney Redentor Viaje. Could you tell us something about this case, Attorney Redentor Viaje's case against you?
Your Honor, what I know is there is only one case, that of Kang Tai Sik, who filed a case against all of us when he was ordered deported by the Bureau of Immigration. Secretary De Lima and myself were respondents in this case. However, what I stressed was that this person, the Korean, filed a motion to reopen the case. And upon my recommendation, I told Secretary De Lima to refer it back to the Bureau of Immigration to hear the case. And that is what we did. When the Bureau of Immigration reheard the case and ordered his deportation and imprisonment and detention in Bikutan, he filed a case against all of us. Well, that is the risk, Your Honor, they say, of public service.
I am sure that you are aware that the rules of the JBC provide that should there be a pending ombudsman case, notwithstanding an earlier resolution dismissing, if there is still a pending motion for reconsideration, then that would be a basis for your possible disqualification for nomination.
I will submit, Your Honor, if that is the rule.
Yes.
But I was pleading to Ombudsman Morales. This case has been pending for 1 year. And were it not for my appointment and my following up the case, it would not have been it would not have moved.
Okay. Yes. Moving on to other issues raised against you. How is your health? How is your health?
Well, Your Honor, because I underwent an operation, a major operation in 2010, when they found a polyp in my abdomen, in the large intestine. So they had to cut it off. But of course, I never prayed so hard in my life that after the laboratory tests, for 4 different laboratory tests, they found it to be negative. It was benign.
Now, we are just concerned because if you just turned 60, is it not? You just turned 60. You turned 60 this year.
I am 60, just July.
Should you be appointed to the court, will you aspire to finish all the 10 years remaining or before mandatory retirement? Or would you consider early retirement upon reaching the age of 65?
No, Your Honor, I would certainly opt to work until 70. This is how I work. When I assumed the position of Chief State Counsel, which, according to my friends in the department, undersecretaries and secretaries before, they said that was a difficult job. But this is my 12th year. Every day that I learn something new, it enlightens me, it encourages me. I wake up at 3:30 just to read all the opinions of drafts made by my state councils. Because in the office, Your Honor, I do not have time to read. There are so many visitors. The secretary will call me. Meetings are come here. On the average, 3 meetings a day.
Thank you, Mr. Chief State Counsel. There is a conflict between your previous boss and your current boss, Secretary Aguirre. What can you say about the apparent quarrel, and how have you been handling this having worked with both now Senator De Lima and Secretary Aguirre?
Well, Your Honor, I was never requested by Secretary Aguirre to work in any of the cases or investigation made on Secretary De Lima. But both, I would suppose, they know my value in the department. I worked with them fruitfully. Secretary Aguirre has entrusted me with several opinions, like on the opinion regarding the validity of coming up with the emergency powers on traffic, the list of exceptions to the freedom of information. These are matters which I would venture that he would not entrust to anyone.
My final question. There is now a move in Congress to reinstate the death penalty. What are your views on death penalty, and do you believe that it is a deterrent to crime?
Your Honor, of course, this is a legislative prerogative. Whenever they ask me for an opinion, that is my standard answer. But the problem with the death penalty is that this is a view. If a criminal is caught in the act of committing a crime and the victim is still alive, and he knows that if the victim stays alive, he will be prosecuted and he will be executed. What will the criminal do? He will kill the person. That is the pros and cons. But of course, if it is proven that it is a deterrent to the commission of a crime, then why not? But we will look into statistics.
Your personal opinion. What is your personal opinion? Should there be a reinstatement of the death penalty?
I would suppose it should be a deterrent, and so I would go for the reimposition of death penalty.
Okay. With that, I wish you luck. Thank you, Mr. Chief State Counsel. Thank you, Justice Gutierrez.
Thank you so much, Attorney Cayosa. May we request Attorney Mejia?
Thank you, Madam Chair. Good afternoon, Chief State Counsel Paras. What do you consider as your significant achievement as Chief State Counsel of the Department of Justice?
Well, there is no specific case because every day I do the opinions. I do opinions not only for difficult questions of law, but opinions on all the loans, the foreign loans contracted by the Philippines. As Chief State Counsel, I am part of the Interagency Committee to review foreign loans under the Monetary Board. We review its compliance with the Foreign Borrowings Act and the ODA law. There is an enumeration of the requisites of an ODA law. This is needed by a developing country. The problem with the ODA law is, of course, most of the creditors want a tied-in loan. Whenever they loan to the Philippines, they want their contractor to handle the project. But what can we do? It's give and take, give or take. And then I also handle extradition cases and mutual legal assistance. I handle the case of Bangladesh because Bangladesh requested for legal assistance because the OSG entered its appearance for AMLAC, and they work for the forfeiture of the fund of 15 million surrendered by Kim Wong. When the fund was declared surrendered or declared forfeited, it was forfeited in favor of the government unless there is a third-party claim. This is where I came in. And so the Bangladesh, they will have a high-level delegation coming to thank the Philippine government for what we did for them.
Could you tell us, Chief State Counsel Paras, an instance in your career where your independence or integrity has been put to test or was put to a test? Your independence and your integrity.
Well, I could not think really of my independence being put to the test. No. For example, our family has never been in business. My grandparents, my father has brought me up the old-fashioned way. So we never had any dealings with businesses or conflict where a member of the family was involved.
Let me now turn to some of the questions tweeted that are being requested to be asked to all candidates. Should justices have a liberal interpretation of the Constitution, or should they adopt a purist view?
I think that it should be liberal. For me, it should be liberal. The law is not stagnant. The Constitution is a living Constitution. It should apply to several circumstances. The liberal view is more as compared to the conservative view. For me, is much more is needed in a developing country like ours.
Thank you. That was my final question. Good luck again, Chief State Counsel, and thank you, Madam Chair.
Thank you so much, Attorney Mejia. May I request Judge Ilaw to continue?
Thank you, Justice Gutierrez. Good afternoon, Chief State Counsel. According to your personal data sheet, your service record has entirely been with the government, beginning as a trial attorney at the Solicitor General in 1984. You have not been engaged in private practice, feeling the impulse of a trial lawyer?
I have never engaged in private practice, although my stint at OSG was like private practice, Your Honor. As a matter of fact, when there was a change in leadership, Frank Chavez, the late Frank Chavez, wanted me to stay with him because Frank was more of a litigation lawyer. He wanted me to be there, but then Secretary Ordonez convinced me to join him to go to the Department of Justice. But through the years, I have, like for example, in my stint in the department, we have also, aside from litigation, we deal with decisions or we rule on the constitutionality or legality of municipal tax or provincial tax ordinances, as well as the disputes between two government agencies on pure questions of law.
What do you have to say regarding the controversies now at the Department of Justice? There's been a report that alleged illegal drug trade as being supported and or protected by certain officials of the Department of Justice, to which you belong.
Your Honor, I had visited the New Bilibid prisons and all the other prison colonies. The problem there is that, for me, the superintendent is the king.
And who is the queen?
So much power.
Who is the queen?
Whoever is the head of that, he wields so much power. And so he can be easily tempted. In the past administration, how many times did they change the Bureau of Corrections director? And they all came practically from the military.
But, excuse me, going back to your service record of servicing the government, I noticed that most of your references come from private sector, lawyers from the Ayala Group, Meralco, and San Miguel Corporation. Can you explain how they have seen and can attest to your integrity, competence, independence, and probity as a public servant?
Well, I would suppose so, Your Honor. For example, Solomon Hermosura, who is the top legal person in Ayala, can attest to my integrity. My wife works as the head of the corporate services division of Ayala, legal.
So, Attorney Hermosura can attest to your wife's integrity, but not your good self?
No, but I know Mon, and there are times that we talk socially, and there are exchanges of legal what is happening in the legal field.
About Attorney Ray Espinosa from Meralco.
Ray Espinosa was my classmate, Your Honor, a good friend, and he was our number one top-notcher in our class of 1982. He is the top man, I would suppose, the top legal executive of the MVP group of companies.
About the last one, Mr. Ramon S. Ang of the
Ramon Ang, I knew
San Miguel Corporation.
because of my cousin. My cousin is an executive of San Miguel Corporation, Oscar Paras Jr., who was once the senior assistant GM of the Manila International Airport.
Most of your knowledge in law, as well as experiences, and as more particularly as Chief State Counsel of the Department of Justice, well confines from extradition cases and legal aid. Would that be enough for you to be considered by this council as an Associate Justice of the Supreme Court?
May I request for to repeat?
With your limited knowledge in law as a Chief State Counsel, merely confined as a Chief State, handling extradition cases as well as you mentioned other cases, would that be enough for you to be, by this council, to be considered, you to be considered as an nominee to the Supreme Court?
Your Honor, in the Department of Justice, the Americans or the foreigners who deal with us are of the impression, and they tell me this, after realizing what I do and the coverage of my work, they say, you know, taking aside criminal cases, which is the work of the prosecutors, all the others are yours. I said yes. From the opinions to the work of to extradition, to international matters, and even refugees, Your Honor. I am the chairman of the Refugee and Statelessness Persons Unit, of which not many know that we are signatories to the Refugee and the Statelessness Convention.
All right, as Chief State Counsel of Department of Justice for over 12 years, what novel changes have you effected in your office that were never effected before by your predecessors?
Your Honor, for one, the influx or the entry of the free trade agreements and our accession to the World Trade Organization in 1994 created a very different aspect on international and even local trade. I believe in the principle that what the Filipino does not know how to do, forget it, don't do it. Let us concentrate on matters which we know what to do, how to do, and then import at a low level of tariff. That is how the international things, the trade is now at present. Of course, we should protect certain sectors like agriculture. We should protect our farmers, because if we import rice from Vietnam which produces rice at a very low cost and we import them. Our farmers will be at a disadvantage. This matters, Your Honor, will eventually reach the Supreme Court.
These are business matters. Can you apply these changes to the Supreme Court if you were appointed as Associate Justice of the Supreme Court?
Will I?
You'd been talking about business matters, as you mentioned, to be changes in the Department of Justice as a Chief State Counsel. Would this apply, these changes, to the Supreme Court?
Oh. No, I was just saying matters, Your Honor, which change the face of the work, which is why what I did when realizing that free trade agreements and brought about by the World Trade Organization would be a thing of the future. I sent out several state councils to Geneva to study these matters. This is what I introduced, whereas before only the Chief State Counsel and the Assistant Chief State Counsel usually go abroad. The going abroad.
All right, thank you. My time is up. No further questions. Good luck, Chief State Counsel.
Thank you so much, Judge Ilaw. Good afternoon again, Chief State Counsel. Okay, in answer to one of Judge Ilaw's questions, you said that when Americans and other foreigners went to the DOJ, they told you, aside from criminal cases, all matters, laws are yours. So, and I understand you have written thousands of opinions. Mr. Chief Counsel, supposing the President requested you, your opinion on whether the International Criminal Court of Justice has jurisdiction over extrajudicial killings, what will be your opinion?
Well, Your Honor, the ICC only exercises complementary jurisdiction, which means to say that as long as our courts are open, they cannot exercise jurisdiction. So we will have to make it a point. And this will be my advice to the President. Keep the courts open. Keep the cases. There is AO number, I think, 99, or there is an administrative order on creating a task force on extrajudicial killings. And it is my view that this should be strengthened. What should happen, and I think this is already the trend, is that we should not be adversarial. There should be a mixture of inquisitorial and adversarial, where the prosecutor should, but the prosecutor who will not conduct preliminary investigation will help the law enforcement in the investigation of a case.
So your opinion will be the ICC will not have jurisdiction over extrajudicial killings in this country because our courts are open.
Yes.
Okay. Counsel, supposing our police, our prosecutors, our courts do not take any action. As it is now, how many have been killed? More than 3,000. But what has the government been doing? Supposing no action has been taken by all pillars of our justice, How can now the ICC acquire jurisdiction over these extrajudicial killings? Supposing we are unwilling to do anything, not only unwilling, but we do not want to take any action, how can the ICC acquire jurisdiction over extrajudicial killings?
Well, Your Honors, the ICC, well, the Commission on Human Rights, the Committee on Human Rights, they can send special rapporteurs in the Philippines, and that would be the start. We should welcome special rapporteurs, although there are some sectors in government who frown upon the entry of UN experts. But let's be open.
Under the ICC provisions, jurisdiction may be acquired in the following manner. The state party may refer. Number two, the prosecutor of the ICC may act on information being received by her or him concerning our extrajudicial killings. And then the Security Council of the United Nations can also, take action by advising the prosecutor to take action and to inform the pre-trial chambers about these extrajudicial killings. So, Counsel, next question is, do you consider or do you believe that these extrajudicial killings constitute crimes against humanity?
Well, Your Honor, if it is of that, while it has not reached that proportion, there is still the claim, although I have not investigated now, that the killings were subject of a shootout, which of course will have to be investigated, and they are being investigated. But if it is wanton already, if it reaches a proportion that there is already tyranny, then of course we should admit that they can assume jurisdiction and let us appear before the court to present our evidence.
Counsel, let us say, the ICC or the Statute of Rome defines crime against humanity this way. It is a crime when committed as part of a widespread or systematic attack against civilian population. Do you consider or do you think that this extrajudicial killings is a part of a systematic scheme as an attack against civilian population? And the crimes may be murder, killing, enforced disappearances. This is the definition of the Statute of Rome.
Your Honor,
A systematic attack against civilian population. And then the enumeration or the provision enumerates all classes of crimes considered crimes against humanity.
Your Honor, if it is not really on the population, but a specific group, criminal elements, Your Honor.
The drug lords, isn't it?
Your Honor, just...
This is the group being attacked. Drug suspects, drug lords, drugs users, isn't it?
But, Your Honor, each case is different from the other. The manner and the circumstances which led to the deaths may have to be investigated and would have to be, and we will look if there is really a systematic, meaning to say a uniform way of doing matter, of achieving the purpose.
Consider these extrajudicial killings as genocide.
As
Genocide. Genocide.
no, Your Honor, because it is not yet, it has not reached the proportion of genocide.
What is your understanding of genocide?
Your Honor, genocide is the elimination of a group of people, of a race. Here, these are criminal elements, and each crime. After all, Your Honor, it is, I think until now, it is there is no. You cannot deny. No one can deny the fact that these are known drug lords. There are evidence in the past of what they are known in the community as people who deal with drugs, which is why their neighbors do not talk.
Yes, because genocide, as defined by the Statute of Rome, is a crime, the intent of which is to destroy in whole or in part national, ethnical, religious, or racial groups. And so we don't think that these extrajudicial killings constitute genocide, right?
Your Honor, it is not yet genocide unless you deal with, as I said, criminals cannot be, it's not a race, it is not a
particular group.
It cannot be a particular group. Nobody can claim legitimacy to a group
and that
of criminals.
You can send that kind of opinion to President Duterte. Next question is, again, I'm asking for your opinion. If President Duterte asks you your opinion on whether it is constitutional or legal on his part to suspend the writ of habeas corpus at present, considering the present situation of our country, will be your opinion?
Your Honor, in the Constitution, there are only two grounds for the suspension of the writ of habeas corpus and the proclamation of martial law, which is invasion and rebellion.
Therefore, your opinion is he cannot.
I think what he should do is to call, which he has done, is to call the calling out provision, which is to suppress.
Calling out power.
Calling out power, which is to suppress lawless elements.
Do you think this?
There is no invasion.
Concerning the calling out power meaning to say he will call the armed forces of the Philippines. Think, on the part of the armed forces, do you think it is successful in suppressing lawless violence, invasion, or rebellion? Present, what is your view?
They can, Your Honor. It can be sufficient, but it will entail a lot of bloodshed. Because, for example, the President Estrada tried it when he called an all-out war in Mindanao, what happened? A lot of people perished. But he wanted to finish them off, were it not for the fact that he was taken out of power.
Last question, Mr. State Counsel. Of course, under the Constitution, the President has the power to declare a state of national emergency, like in cases of typhoon, pestilence. But why is there still a need for Congress to pass a law authorizing him to exercise that power, declaring a state of national emergency? Can he not just, perform acts provided by the Constitution without the law from Congress?
I think, Your Honor, the reason is because the President is being equipped with a power which is not allowed by law. For example, if he wants to, there is an infrastructure destroyed. He wants it immediately repaired or put up again. Then he can be empowered to award it by negotiation.
Can you apply that on our present traffic mess?
It can.
In your opinion, what do you think Congress will provide in its law authorizing the President to take action as a remedial measure with respect to our traffic congestion? Can he not take over private utility or buses for public use to be operated by the government? Can he do that if there is a law?
But it would be better that there is a policy provided for by law.
That's right, Counsel. That law is needed so that there can be a national declared policy on the part of the government. Thank you and good luck.
Okay, thank you. Thank you, madam.
The last candidate to be interviewed is Court of Appeals Associate Justice Noel G. Tiham.
Justice, please
Good
take your
afternoon,
seat.
Your Honors.
We will continue with the public interview, so may we request Attorney Cayosa.
Okay.
Thank you, Madam Chairman. Good afternoon, Justice Tiham.
Good afternoon, Your Honor.
We last interviewed you on May 12, 2014. Have there been anything significant in your career as a justice that you feel we should know about?
Well, I'm now the chairman of the 4th Division in the Court of Appeals. I think I have decided more cases. And then since 2014, I was also sent by the Supreme Court to attend a seminar in Thailand on cybercrime. And personally, over the years, I have a profound understanding of the judicial system and of what I felt are the pressing reforms that should be instituted based on my experience as a trial court judge and also based on my lectures, MCLE lectures to lawyers and also my lectures to judges as well, and personal interviews I conduct with litigants and their seeming frustration about delays in the judicial system.
Briefly, could you tell us what would you propose should you become a member of the High Court as a way to improve the administration of justice that would greatly impact how trial court judges would, be able to dispose of their caseload? So something novel, not yet experienced by the court.
Well, the innovations made by the Supreme Court are are outstanding and good. The judicial affidavit rule, efficient use of paper, and other things. But in my lectures, my interaction with lawyers, my interaction with judges, there seems to be really a delay, which is not attributable to the fault solely of lawyers or to the fault solely of judges, but I think it is what I perceive to be the infrastructure of delay. I'm talking of the organization as it is. You have the first level court, you have the second level court, you have the appellate court, then you have the Supreme Court. In my lecture on pretrial, the circular issued by the Supreme Court is outstanding because it mandates lawyers and judges to lay their cards on the table during the pretrial conference. So I realized that a case, when filed in court, is either meritorious or not meritorious. So therefore, if it is not meritorious, then the judge should himself automatically dismiss the case. And so with lawyers, in my MCLE lecture on legal ethics, I always propound the question, what happens if a client consults you about the case and it is not meritorious at all based on the documents shown to you, the evidence shown to you? What should you do? And I tell lawyers that if you are ethical, then you should be candid and honest to clients and tell them that this is a losing case. So that is one thing I'd like to articulate. I'd like to talk to the lawyers. I'd like to talk to the academe. I'd like to talk to the judges. I would like to explain to them that courts were created not for the benefit of lawyers, not for the benefit of judges, but for the benefit of the public. The courts are there because they're supposed to settle disputes, controversies. And there is no rhyme, reason, and logic for a case which is meritorious to go through the whole process of passing through the first level, go to the second level, go to the appellate court, and go ultimately to the Supreme Court. And because of the perception that the Supreme Court is the final arbiter, a litigant with a meritorious case has to wait until it reaches the Supreme Court before he gets relief. That might be a simplistic way of looking at things. In the same token, if a case is initially not meritorious, then it should be dismissed outright. That is why probably one reform that we should initiate is that we should impose some kind of sanctions to lawyers who file cases which are not meritorious, motions which are dilatory, and even appeals which are frivolous. Now, it might appear as fighting a windmill, but what I propose to do is to convince the Supreme Court to call a consultative summit, the same as the summit called by Chief Justice Puno I was a part of it, on extrajudicial killing and enforced disappearances, the summit on access to justice, and other summits. And this was a very unique and a bright approach because this is similar to a JELAC, a consultation of the judiciary, the executive, and the legislative, because the Supreme Court invited resource speakers from Congress, resource speakers from the executive department, out of which they were able to craft the writ of amparo and the writ of habeas data. Now, I'd like some kind of a consultative summit to discuss this infrastructure of delay. Now, if it is not, if it is, this will of course be resisted by lawyers and judges. And because of the orientation of lawyers and judges, lawyers are taught in school that they have to go to trial so that they can win the case for the clients, okay? Which is wrong, because if from the very inception the case is not really meritorious, there is no need to go to trial. That's why in pre-trial we teach lawyers and judges about stipulations of facts, modes of discoveries, and things like that. So I do not think, no survey has been made insofar as the litigants are concerned whether they're happy with the decision, even if they win the case after 5 or 10 years in the Supreme Court, for example. Nobody conducts a survey and asks the litigant, are you happy with the outcome of the case? And in all probability, they are not happy. That is why we have to teach lawyers that they are, we call them the priests in the temple of justice. If they're able to settle the dispute between the litigants, then they're successful. And if they are not able to settle the dispute, then they're not successful. We have to reorient because...
Excuse me, Justice. In as much as there are other matters that I would need to inquire from you,
all right.
Perhaps you can move on to the next topic.
Okay. You're right.
Incidentally, how is your health? Have you had any major procedure done on you lately?
Yes. I had a heart bypass in 2005. It was asymptomatic, meaning to say I did not feel any symptom. But since I had consultations, lab tests, and it was found out, then I had a heart bypass in 2005. I had an angioplasty in 2012. It was also asymptomatic because I see to it that I consult I have a cardiologist. I consult him at least 4 times a year. I have my lab test every quarter. And then I have a pulmonologist who checks on me. I have an ENT. I have a prostate doctor with me because of my age. I have a knee doctor also. And they have already issued medical certificates attesting to my health.
In January of next year, you will turn 68.
Yes, Your Honor.
So that would leave you with 24 months before you reach the mandatory age of retirement of 70.
Yes, Your Honor.
With 24 months, and if you are to be nominated and appointed to the High Court, you would have to take on over 1,000 cases, which would translate to roughly a minimum of 40 decisions monthly. I was looking at your average monthly disposition per your personal data sheet, and it states 11. How do you expect to be able to finish the caseload that would be given to you within the time frame prior to your
Well, it remains
retirement?
to be seen, and I have no pretensions that I can finish that much compared to the other justices in the Supreme Court. But what I'm saying is that within the limited time frame, the limited period of time within my judicial career, I'll be able to concentrate not only on the disposition of cases, but also the judicial reforms I was trying to articulate. As far as I'm concerned, this is a way of I'm not fixated about going to the Supreme Court for myself. I was asked that question in 2009, and I said I wanted to be in the Supreme Court because it's the dream of all lawyers. Now, in the remaining period of my judicial career, it's more altruistic. I want to pay forward. I want to institute reforms. I want to articulate these reforms to lawyers, to judges, and even to the court, which I cannot do with authority and probably influence as a Court of Appeals justice.
Thank you, Justice Tiham. That was my last question, and
Thank you.
good luck.
Thank you, Your Honor.
Thank you. Thank you, Justice Gutierrez.
Thank you so much, Attorney Cayosa. May we now request Attorney Mejia.
Thank you, Madam Chair, and good afternoon,
Good
Justice
afternoon, Your Honor.
Tiham. What is your view on justices socializing?
Well, it invites undue influence, but the upside of it is if you socialize with people and you have your pictures taken, then you can use that as a reason to inhibit from the case. That's why when I attend alumni homecomings, I always have a picture taken with my co-alumni, and I always tell them, if this picture comes out, I have no other choice but to inhibit. But I think socializing when you're in the appellate courts should not be, it should be limited. It should be restricted. Probably socializing with fellow members of the judiciary would be okay.
In an ideal setting, Justice, how much access to the court should be given to the public?
Transparency, access. I think they should have more access in terms of active representation, so that their cases are heard. Insofar as access to documents, court records, I think they should be given access. They should be given proper representations. I know that there is a public attorney's office in the Philippines, which is similar to the public defender's office in the United States. But it may be a good idea, if worth looking into, if there are very few POW lawyers to attend to not only indigent but clients or in need of lawyers, there might be a need to adopt something similar to the United States, where even private lawyers are allowed to render services, but they're paid by the state or something like that.
Let me turn to one or two Twitter questions.
Okay.
You announced in an MCLE session that you were President Duterte's classmate. Considering your closeness to the President, how can you maintain your independence?
Well, that's a valid observation. Independence. I know this President. I know where he's coming from. He's full of pride. He's not that kind of a person who would ask favors. Let me just briefly tell you, Your Honors, that I was appointed by President Ramos in 1994 as RTC judge. I was appointed by President Gloria Macapagal-Arroyo in 2003 as Court of Appeals judge. And none of them had ever made any overtures to approach me about cases. I was appointed by President Ramos as RTC judge, and yet I decided the case of the writ of habeas corpus case of Filimon Popoy Lagman, an NPA leader who was arrested without warrant by the police at that time, and I ordered the release, and I granted the writ of habeas corpus. Gloria Macapagal-Arroyo, President Gloria Macapagal-Arroyo, I decided during her incumbency, I issued a writ of amparo against her and Gilberto Teodoro Secretary of National Defense and other generals in connection with the abduction of Phil-American activist Melissa Rojas. And then I also decided the case of the midnight appointees of President Arroyo, thereby revoking almost 600 midnight appointees. So what I'm saying, Your Honors, is that presidents or even their subalterns do not really make any attempt to influence judges as a general rule. And I have never experienced that. Now, with this president, I don't know if he knows, he remembers me. I don't even belong to any fraternity in Sambeda. And knowing him, he's full of pride, you know, his personality. He would be the last person to ask favors from people in the judiciary.
My final question. Good luck, Justice Tihan, and
Thank you, Your
thank you,
Honor.
Madam Chair.
Thank you so much, Attorney Mejia. May we now request Judge Ilaw.
Thank you, Madam Chair. Good afternoon, Justice Tiham.
Good afternoon, Your Honor.
Your present caseload is 91, and your average monthly disposition is 11. Do you think this disposal rate is sufficient enough, given the caseload you have?
Yes, Your Honor. Taking into account that in the Court of Appeals, you do not only attend to your own decisions, but also the decisions of the other members of your division. I'm the chairman of the 4th Division, and occasionally you are included in special divisions in the Court of Appeals. Now, there might be improvement on my part to increase the output, the caseload output, considering that there are more lawyers given to justices in the Supreme Court rather than in the Court of Appeals.
All right, there is a Twitter question here that's addressed to all the candidates.
Yes, Your Honor.
How do you view the credibility of the current Supreme Court?
I think the Supreme Court has maintained its utmost credibility as the last bastion of justice. People always look at the Supreme Court as the final arbiter of all controversies. That is why even litigants who are in a hurry, instead of filing cases before the lower courts, they immediately file cases before the Supreme Court. So I think that's a recognition of the respect and the high esteem given by the public.
You have mentioned your advocacy or reforms to be undertaken if appointed to the Supreme Court. People are aware of any internal strifes between justices in the Supreme Court. What reform or advocacy would you intend to do if appointed to the Supreme Court?
I'm sorry, Your Honor, internal strife?
Yes, this is common knowledge.
Well, I think
When tradition is been broken in the
of course.
appointment.
Even in the Court of Appeals, there are dissensions. But what I'm saying is, if there is a commonality which does not involve the interpersonal relationship between the justices, I think the members of the court may be persuaded to pursue something higher than their own personal interests. Most of the incumbent justices are personally known to me. Most of them came from the Court of Appeals. Some of them came from the Regional Trial Court of Quezon City, where I came from. 2 of them are my classmates, by the way. So I think it's a matter of enticing them to pursue something higher than their own personal interests.
Areta, having been in the practice of in the private sector as well as in the government, you have seen both sides of the spectrum and the disconnect between the two practices. As a justice of the Court of Appeals, have you addressed this disconnect in the effective pursuit of serving justice?
Pursuit of serving justice. The disconnect. Yes, Your Honor. The delay is a frustration to all litigants. And I was talking of reorienting the mindset of lawyers and judges. Lawyers look at cases in court as a source of income, and judges look at it as a source of power and influence. That is why some judges are wary about having their cases consolidated with the cases of other judges. So the disconnect is because the lawyers, the judges, are not in sync in looking at the purpose why they are in the court. Their principal client are the litigants, the public. And if I may just add, when President Duterte, when he took his oath, he said something about queuing. He doesn't want queuing. I think he was being polite and modest. As a lawyer, he knew that the longest queuing is in the judicial system. That courts are there to help the litigants settle their controversy at the soonest time possible. And I would like to achieve that by convincing the court to introduce certain reforms. Justice Abad was almost successful in pursuing that reform pattern after the European system of confrontational, wherein the judge takes an active role in the trial, and I was invited to be a member of that committee.
You attended and was the Master of Ceremonies of the 2011 Anti-Illegal Drugs Forum.
Yes, Your Honor.
What did you learn from that forum that you could apply today in support of the present administration's war against drugs, or illegal drugs?
Yes, it was actually...
If appointed as a justice of the Supreme
Your Honor,
Court.
it was actually sponsored by the Supreme Court, and there were participants from the Department of Justice, participants from the PNP, participants from the military, and I think at that time Secretary of the Interior and Local Government, Secretary Robredo, was even present. That was months before he died. Now, in support of the campaign of the President on illegal drugs, I'd like to mention that a few years ago, I conducted lectures on searches and seizures among police officers, and I think they're very receptive to getting some kind of orientation from the judiciary on relevant jurisprudence that would make it valid and legal for them to conduct valid searches and seizures. And I was even suggesting to them that they should carry with them some kind of a handbook, so that at any time they can always refer to it and consult it on what is allowed and what is not allowed. So in that sense, the judiciary can support the campaign. Now, another way of supporting the campaign of the President is by deciding drug cases as swiftly as possible, even if we dismiss drug cases. But in the process, we tell the government about the pitfalls that should be avoided and the things to be followed to pursue a successful prosecution. Then in that way, we will be able to help the campaign of the President.
You likewise attended the two-day National Consultative Summit on Extrajudicial Killings and Enforced Disappearances in 2007. What have you learned from this summit that could be applied today in relation to the purported extrajudicial killings?
Well, the issuance by the Court of the writ of amparo, the writ of habeas data has been an instrument to protect the helpless, the weak. Up to now, we are, even in the Court of Appeals, we are conducting hearings relating to the writ of amparo and writ of habeas data. Even the case I decided 2 or 3 years ago, the case of Melissa Rojas, which went up the Supreme Court, was remanded back to us for the purpose of looking at the actual perpetrators of the abduction of Melissa Rojas. It is still pending in my division, Your Honor.
All right, thank you very much, and good luck to your journey, Justice.
Thank you.
Thank you so much, Judge Ilaw. A while ago, in answer to the questions of Attorney Cayosa and even Judge Ilaw, you were discussing about delay.
Yes, Your Honor.
You know, this is my observation, Justice. No matter how many consultative summits, no matter how many circulars, memoranda, no matter how many classes are being offered by the PhilJA, if the judges are lazy, no way. There will always be delay. So it depends upon the personality of the especially trial judges. That's why they should be encouraged, they should be taught to change their attitudes. This is the basic reason why there is delay. The judges are unconcerned of their mission. The judges are tamad. That's my observation. You know, during our time in the RTC of Manila with Justice Pardo, Justice Callejo, et al., there were no complaints about slow disposition of cases. So this is really a very, very big problem because it concerns the attitude of judges. Well, I'll go to another. This is the first question. Do you think Rule 65 is an obstacle to speedy disposition of cases?
Well, petitions for certiorari, while a case is still pending before the lower court, may delay the prompt disposition of the case before the lower court, but it affords the litigants the opportunity to bring to the Court of Appeals the question of grave abuse of discretion, which can be corrected as soon as possible, Your Honors. So it's a way of balancing things.
You know, that, as what you said, sometimes lawyers are abusive. For simple orders issued by the lower courts, they would go up to the Court of Appeals or to the Supreme Court.
Yes, Your Honor.
Are you a member of the Committee on Rules?
Yes, Your Honor. I am a member of the Committee on Rules.
You can recommend that all these lawyers should be penalized, just like in the States. You know, if they raise pleadings, motions, which are really unmeritorious, they are being fined or even sent to jail by the courts concerned. So maybe, you know, you can take action on this matter.
Yes, Your Honor.
Anyway, you know, one of the rules of the JBC in determining the qualifications of candidates for nomination is to test their mastery of laws, rules, and regulations. Anyway, simple question, Justice, because you're going there to the Court of Appeals if you are lucky enough. There are 4 requisites when a petition questioning the constitutionality of a law, statute, or executive issuances are required before the court can take action thereon. So what are these four requisites
Well, there
before
must
a
be-
constitutional issue may be looked into by the court?
There must be an actual controversy between the parties. The parties filing the case must have legal standing. The question of constitutionality must be raised
At the earliest.
at the earliest time possible, and that the issue of constitutionality is the main core of the controversy that has to be resolved by the court.
You mentioned about locus standi. When can a private citizen, for example, you and I, go up to the Supreme Court questioning the constitutionality of a certain law?
Well,
The question is, do we have locus standi?
there's such a thing as a taxpayer suit.
We are not taxpayers. You and I are ordinary citizens.
Well, if it involves a public right, probably that would affect the public, and even if we do not have, in some cases at the Supreme Court, I came across, even if there is lack of legal standing, if the matter is of transcendental importance, the court would take cognizance of it.
So you and I are raising a matter of transcendental importance here.
Yes, if
Correct.
it is.
What is the other ground?
A public right, Your Honor. If it's a
No,
public...
you and I have sustained a direct injury,
The direct injury
because of the unconstitutionality of the statute we are questioning.
Yes,
Okay, one of the prominent cases decided by the Court of Appeals last year is this case concerning Mayor Junjun Binay, where in your court issued TRO. And the case reached the Supreme Court. What was the decision of the Supreme Court penned by Justice Bernabe?
It said that the condonation doctrine has been abandoned, but the pronouncement is prospective.
Yes,
Prospective.
that is correct. But what is or are the grounds relied upon by the Supreme Court in ruling or declaring that the application should be prospective? Meaning to say, condonation doctrine is no longer acceptable. So what are the reasons?
Well, the condonation doctrine has been abandoned because violations of the Anti-Graft and Corrupt Practices Act should not be erased by the mere election of the respondent to public office, I think, because a public office is a public trust.
Officers and employees are required at all times,
Yes, Your Honor.
even if before election, because election is not a mode of condoning
Crimes.
not crime,
yes,
administrative offenses.
Yes, Your Honor.
Okay. Next question is, Justice, do you think President Aquino can be charged criminally on the basis of the declaration or ruling by the Supreme Court that DAP is unconstitutional?
Presidential immunity ceases.
No, now that he's
Now,
no
yes,
longer
yes.
president.
Presidential immunity ceases when the president is no longer the incumbent, so it can be filed. I do not know, Your Honors, exactly the basis, and this is something prospective which may reach the court. And whatever opinion I will share with you might be resented by the few remaining friends I have in the Supreme Court, and it might be construed also, as well as prejudgment.
Don't worry about it, Justice. You are safe here.
This is recorded, Your Honor. I don't know exactly the elements of the crime that will be embodied in the information that may be filed. I don't know. I don't have any complete appreciation of.
But have you read the decision in the DAP?
Not very well, Your Honor.
But you have an understanding of
Yes,
its
I
rule.
have an understanding about the statement about. I'm sorry, I could not remember the phrase already. Post-operative fact or something like that.
Operative fact doctrine.
Operative fact doctrine.
What is it? What is the meaning of it? Just
It completely escapes my mind, Your Honor. I'm sorry, Your Honor. I cannot give you a complete answer on that.
operative fact doctrine is the existence of laws or issuances declared unconstitutional, but all the acts done prior to such declaration remain valid.
Yes, Your Honor.
So, on the basis of that, do you think President Aquino can be charged?
I do
Is,
not know,
number
Your
one,
Honor.
is
I do
first,
not know,
was he the author of the DAP? Because under,
I think
pursuant to that decision,
as-
only authors can be charged
Well, it's a matter
criminally.
of evidence. The budget preparation emanates from the Department of Budget, which is under the office of the
That is
President.
disbursement acceleration program.
Yes, Your
Meaning
Honor.
to say, the office of the president, spend funds
Yes, Your Honor.
from other sources. And then, of course, you understand what is cross-border transfer. That is the DAP.
Yes, Your Honor.
So,
It's
I give you the read that decision. So good luck.
thank you, Your Honor.
Ay, salamat. So, yeah.
That's all for this afternoon, Your Honors.
And so, the public interview of applicants for the vacant positions of the Supreme Court is now adjourned today.
At inyo na pong natunghayan ang pagkatapos ng ginagawa po ngayong public panel interview. Dito po yan sa loob ng Korte Suprema na pinangunahan nga po ng Judicial and Bar Council. Sa mga oras po ito, makakasama po natin ngayon si Attorney Cynthia Rojas para mas malaman po natin kung ano ba yung iba pang mga kahulugan ng mga na-discuss kanina. Attorney Cynthia, magandang hapon po sa inyo.
Magandang hapon sa iyo, Kirby, at maraming salamat sa inyong imbitasyon upang makapagbigay din ng aking mga kuro-kuro sa mga nangyari ngayong araw na to.
Attorney, paliwanag muna natin, bakit ba nandito tayo ngayon? Of course.
Nandito tayo ngayon dahil sa bagong kautusan na ang lahat ng mga nominado para sa Supreme Court ay they have to go through televised public interview which is conducted by the JBC. Una sa lahat, sino ba ang dapat na maging nominado para sa JBC? And there are at least 3 qualifications that natural-born citizen ang kandidato, at least 40 years old, and that has been in practice for the past 15 years or is a member of the judiciary for the past 15 years. According to the Constitution also, dapat a person of known probity, independence, and competence. Yan ang mga requirements ng ating mga nominado para sa JBC.
Bilang nabanggit nyo na po yung mga qualifications, ano ho ba talaga ang tunay na function